Thank you. Oil and gas. Prior joining Rion, Martin was entrepreneur who founded two companies and also worked in consumer products in Procter & Gamble, as well as in management consulting in Boston Consulting Group. He has an MBA from the Stanford Graduate School of Business. He has a BS in Industrial Engineering with honors from Instituto Tecnológico de Estudios Superiores de Monterrey. He has served as a board of directors of various companies within sectors such as pharmaceuticals, manufacturing. He has been expert witness on damages in several investment arbitrations on behalf of the Mexican government and also on behalf of the Dominican Republic. And he's member of the Mexican National Rowing Team and the Central American Caribbean Games silver medalist. We also have Richard Caldwell, that he's principal in the London office of the Brattle Group and has been with the firm for over 20 years. Richard is an economist and a financial expert with experience evaluating business and financial instruments across a range of industries, from electricity to banking, telecom, and a range of settings. He provides economic and financial advice concerning corporate finance and valuation, the pricing of securities, assessment of regulatory issues. Richard is also or has advised the European Commission and national regulators on financial issues. He has testified before the UK Competitions Appeal Tribunal. He has been expert on damages in close to 50 international arbitrations before tribunals set up in the Energy Charter of Treaty, the London Court of International Arbitration, the ICSID, UNCITRAL, Dutch law, Swiss law. He has worked on behalf of both claimants and respondent. And he also is retained as an expert witness in several international investment arbitrations related to Spain on energy renewables. And he was formed, his analysis has so far formed a basis of roughly €1 billion of arbitral awards on behalf of renewable investors. And Mr. Caldwell also regularly teaches a core corporate finance and valuation course in the Masters in Finance program in the London Business School. And we have also Rafael Bosa, that he's a special counsel in Chapman Pillsbury, focuses his practice in all aspects in international arbitration and dispute resolution. Rafael has almost 20 years of experience in domestic international litigation and arbitration, and provide clients with early identification and mitigation of business risk and plan of action that could occur during those type of disputes. Rafael is also is representing clients in transactions and corporate matters, enjoying a diverse and mixed practice. Rafael is a fellow in the Texas Bar Foundation and devotes time pro bono efforts in dispute resolution. He lives in Houston, and it's a pleasure to me to have you here in this meeting. And I will start introducing the issue that we will discuss, and I will make questions that the three panelists will provide her views and clarify many aspects on this particular session. That the session is a reflection on why do need or not need treaty provisions related to damages. The subject matter of damages is, you know, is one of the most complex areas of international investment arbitration. Sometimes damages, compensation, reparation, restitution are used as a synonymous, but the meaning sometimes is completely different or has some differences. Bilateral investment treaties usually does not contain a provision of compensation or damages to provide guidance to arbitral tribunals, except of the standard of compensation for a lawful expropriation. So we should start reviewing what we have in the draft articles on responsibility of the states for internationally wrongful acts in Article 31, that says that responsible state is under an obligation to make full reparation for the injury caused by the international wrongful act. It also says that the injury includes any damage, whether material or moral, caused by the internationally wrongful act of the state. So it is well known that this obligation of make full reparation is one of the key obligations for the responsible state. This general principle is the consequence of the famous case that was heard by the Permanent Court of International Justice in 1988, 100 years ago. That is the case in the factory of the shore saw. And these cases are relevant precedent for arbitral tribunals in investment arbitrations, since provide this general principle of reparation should be made for violation of international law. So, considering that reparation may include compensation or non-pecuniary remedy like restitution, compensation has been or has become the most remedy used in investment arbitration. And all this session relates to this part, the compensation in terms of monetary terms. The term damages generally refers to the monetary compensation awarded to the claim for losses incurred as a result of the respondent action. So our panelists will we will ask some questions related to this aspect of international arbitration. And the first question is, to what extent do investment treaties deal with compensation or damages? And we will start with Richard.
Sure, thank you. It's lovely to be here. This ultimately is a question for the lawyers about what the treaties say, but let me give you my sense of it as someone who gets asked to assess damages from time to time. So the main thing, of course, is the fair market value standard for expropriation, so the FMV standard. Now, I guess the question is, fair market value is a very common term. It's a generic term, really. There are various, you can type it in, you could type it into ChatGPT and get a definition, I'm sure. But there are various generic definitions that different bodies come up with around the world. The typical definitions will include the concepts of hypothetical buyer and seller, unwilling, unforced, knowledgeable. And so it's sort of it's a hypothetical transaction, and it's the price in such a transaction between hypothetical buyers and sellers, knowledgeable, unforced, where proper marketing has occurred is also a key part of some of the definitions. So that's what we're talking about when we're talking about fair market value. What else should I say? What else do treaties do? Well, they don't define similar standards for other types of breach, such as fair and equitable treatment. That's left open. Typically, where that goes then for damages analysis is an attempt to come up with something that approximates to full compensation. Now, even where you're aimed at fair market value, treaties don't specify valuation method. So you won't get, it doesn't say, please do a discounted cash flow method. Please do market comparables or something like that, or some other valuation methodology that you can think of. That's left open. Another important thing that's left open, particularly for FET claims, is the valuation date, when you actually assess damages. So do you do it at the date of the breach, or do you do it at some point later, for example, approximating the date of the trial? And the date you assess obviously determines, among other things, the set of information you have at your fingertips to assess the claim. And so that can be have very significant impact on the overall numbers, particularly in volatile markets, for example, commodity markets, where prices change significantly over time. I guess the question for us, and I'll stop now, the question for us is whether the lack of specificity in the treaties is a good thing or a bad thing. Is it good because it allows then tribunals to deal with the specific facts that are at issue in a given case, and you need that flexibility to be able to handle that, those complicated and different facts that are coming out? Or is the lack of specificity a problem that then leads to inconsistencies and sort of weird results between cases and ultimately a lack of predictability? So let me just put that out there, and then the discussion can carry on.
Martin.
Thanks, Jordan, and thanks. I think that was a very good introduction. And just to add a little bit on what you said in terms of whether there should be something specific in the treaties. If you were very specific in the treaties, you would not be recognizing that certain endeavors, investments, are at different points in time. You could have a deemed expropriation of an investment that is only occurring, that hasn't operated yet. Would that be treated similar to a company that has operated for many years? And so if you're very specific, would you not be missing out, or would you be trying to measure something with a standard that you cannot really use to measure that specific investment, right? So those are the questions, of course, that we need to pose in answering and trying to answer whether or not, or in how far a specific treaty should be regarding the valuation of damage. Right?
So returning back to the history, why do you think that a damages provision, a specific damage provision, was not appear in, I would say, bilateral investment treaties? Okay.
Thank you. And I wanted to, before I start with answering the question, I wanted to thank the university for hosting us. And I wanted to make clear that I am not an expert in damages. I am an attorney, and I call on this gentleman to assist me with damages. So with that said, why was there not more specificity on the clauses, or why are there not clauses on damages in treaties? I think it's a little bit of a historical issue with the treaties themselves and how the nations have developed their treaty relations, you know, and how have they developed the documents that control how they connect to each other. Back in the 1700s, even when the United States was first gained its independence, the United States started signing treaties of friendship and amity and commerce with a number of nations that included principally protection of property, but real property or ships or merchandise. And that was the basis of most of the treaty disciplines that we have even today, even in the 1990s, after everything was restructured through the upcoming of the BIT as an independent and as a sole form of a treaty. That was a response to the prior situation that was, you know, we're only protecting property and we are not recognizing the fact that we have evolved. And that evolution requires that we now protect services, that we now protect other aspects of the interactions between parties and countries, and that really impacted how the treaties were drafted.
Okay, so Richard mentioned something that besides the lawful expropriation, the fair market value provision that appears in almost all bilateral investment treaties. What should be the proper method or proper standard for compensation in cases of other type of violations? Let's say fair and equitable treatment, in your view. Who wants to start? I
want me
have
to
the
do it?
questions, not the answers, so.
Okay, so let's start thinking about this issue then. Okay, so one question is, what does FMV entail when you're estimating it? And now, fair market value as a concept is as of a particular date. It's the value of a transaction between hypothetical buyers and sellers on a given date, right? And that makes sense in the expropriation context. If you then have an FET breach, if you were to apply FMV to that breach, then presumably we have to say it's FET as of a given date. Is that the date when the breach happened? Is it some later date? So it immediately raises that question for you. Related issue on that goes to the question of at what stage is the asset in question when the FET breach happens? Is it an asset in development? Is it something that's in the midst of construction? Is it something that is already operating and has been for some time? And so again, when risks are different along that timeline, which will have consequences for how you then go about valuing the impact. And so this complicates matters in the FET scenario, where sometimes the effect of a breach emerges over time. Sometimes an FET breach can be a short, sharp thing, in which case you can identify a date very easily. You can then quantify as of that date or another date if you choose. Sometimes the fact pattern is more complicated. There may be one FET breach whose effects emerge over time. When the breach happens in the beginning, you don't know, or people don't know exactly how that's going to play out. Sometimes it's followed by another FET breach later. And again, what are you going to say if you adopt an FMV standard? That means you would do one set of damages for the first breach on the date it happened, a second estimate on the date of the second breach, and so on and so on and so on. And so the analysis actually could become quite complicated if you apply FMV to some types of FET breach. Sorry, the terminology is difficult. FMV and FET all at the same time. Now, third thing is that when you're computing FMV, that is only one possible valuation standard. There are other standards that are out there that differ. There's the concept of equitable value or fair value between two specific parties that you can identify. So specific parties might have particular synergies, particular interests that play between themselves, which cause the value in a transaction between them to differ from a hypothetical transaction between hypothetical buyers and sellers. And so if you adopt FMV for FET claims, then you would immediately be ruling out any of these sort of idiosyncratic things that happen between particular people in particular investments, right? And then a fourth observation I would make in terms of whether FMV is a good thing to apply to FET is then in an FMV calculation, you're going to have to think about things like valuation discounts and premiums. You know, so the classic things like illiquidity discounts or discount for lack of marketability. You might look at the value of control or a minority discount that a particular party has in a given investment. So if you're applying FMV to FET, then those types of considerations are going to have to come into the FET calculation too. So the point is, I guess, adopting FMV for FET as well as for expropriation would lead to some complexities. It certainly wouldn't necessarily fit all FET claims, which can have complicated fact patterns. So in the end, I think it raises it's interesting, but it raises a bunch of complexity, which you might not want to bring in a one-size-fits-all type way.
Right, thanks. So that was a very good explanation. Perhaps one way to answer that is to understand what the fair market value standard really is, right? So if you're compensating somebody for the fair market value, you're compensating that person for the entirety of the value that that specific asset could have generated for that person going forward, okay? Generally speaking, right? And of course, the fair market value standard is, as you correctly say, the value at which a willing buyer and a willing seller would exchange that asset among themselves, right? With the full knowledge and without being pressured to do so, which is very important. Of course, our experience is more in the actual transaction world. We're not necessarily so focused on the damages world, where all these valuations are hypothetical. So we have the benefit of whenever we do a valuation of an asset with whatever mechanism or whatever methodology we use, we have the benefit of then going out to the market and checking if we were right or not, right? And that tends to hone our aim a little bit over time, right? I would like to think that we become better at estimating the value of assets because of that. Else we would be out of a job, right? We wouldn't make any money. But generally speaking, when we do that, we do recognize that an asset has, or the value of an asset is the higher of the value of the actual assets. So let's say the reposition cost of those assets, if you were to go out to the market and buy the machines and you were to go and buy the real estate and so on, or the value of the cash flows that those assets will be generating in the future, whatever is higher. It's not one plus the other, it's one or the other, okay? And so we have to be very careful in estimating those future values, because that, of course, is a very, let's say, biased exercise to start with, because nobody knows the future, right? Even when you go back in the context of a damage, you have to go back in time and try to establish a value at a certain point in the past. But then you have to, go back and then position yourself in the past as if you were in the past and the future was unknown, right? So you have to do a prospective analysis of the cash flows that specific asset could generate, and that, of course, is subjective in itself. And then decide or look if the value of those assets brought to present value is higher than the value of the individual assets, right? So it's but in both cases, and that reaches the fair market value. In both cases, that would repair the damage for the entirety of the asset. Okay, and in certain cases, that is not warranted. So that approach would not apply if the damage was not, or the compensation would not require the full compensation of the asset. Okay, and one thing, just going quickly back to the projections, as one very smart investor once said, when I see a projection, it doesn't tell me anything about the future. It tells me a lot about who made those projections, but nothing about the future, right? And so we have to be mindful in the context of a litigation that, the claimant usually will exaggerate, so to speak, or try to interpret a very rosy future for those assets, and hence come up with a very attractive valuation for the asset. On the contrary, the defense will always come back with a very gloomy interpretation of the future, and hence a very low valuation for that asset. How to convince a tribunal on what is fair? I think, taking references from the market showing what has happened, what has actually happened in the market. And if you go back in time, what actually happened back when the relevant damage is supposed to have happened. I think that gives some perspective on what the right standard could be in a very specific case. Huh?
Compensating for fair and equitable treatment is extremely difficult, as this gentleman have explained. Fair and equitable treatment in general is a very elusive concept, and we cannot talk about it without talking about, Near, for example, in the 1920s, Secretary Cordell letter to, incidentally, the Mexican ambassador, claiming that expropriation needs to be fairly and justly compensated. And the expectation of the party owning the property is to keep the property and profit from the property. So if it's taken by the state should pay as a fair response to their actions. But the concept of fair and equitable treatment and the minimum standard of treatment of foreigners has been for forever very elusive and very fact-based analysis. So you have to really evaluate the case on its own merits and be able to determine, with the techniques that the gentlemen have explained to you, that the case merits a compensation for that particular type of injury.
Let me introduce two issues for your consideration. One is what happened when, for example, you have this breach separate of expropriation that does not entail a complete loss of the investment, or the investment continues to be perhaps they receive some type of damages, but it's not a complete deprivation of the investment. And the other aspect that I want to ask you is about the causal link between the loss and the breach, and whether investment agreements should clarify this aspect, that the damages should be, there should be a causal link between the loss and the breach that has been developed by the cases. No? What is your view? Who wants to start?
Do you want me to
Whatever.
take that first again? Okay, so if an FET breach is in a sense partial, you haven't had your asset wiped out, well then of course you cannot claim the full FMV for the asset, right? I mean, because that reflects the full expected value of what the assets going to generate. You need to, FET damages estimation requires a very careful and coherent construction of a but-for or counterfactual scenario, which is absent the breach, versus an actual scenario. And what you're really saying, what you're saying in your question is that the actual scenario, there's still some value there. So you could still apply the FMV standard, right? I mean, you could do the incremental loss in the FMV. That's possible. But it would definitely be the incremental effect, and not the total. That's the first observation. And then I think the second part of your question was about causation. Well, I mean, I'm going to go in the same direction. Any decent damages analysis has to reflect but-for and actual, right? And but-for being constructed in a coherent way that matches to the claims that are being put forward, and that develops both from a legal perspective on causation, but also from an economic view of causation, what the breach, what happened. If it's divorced from that, then you're not computing damages anymore, is what I think, what I would say.
I agree. And I think that the fact that each treaty has different language forces you as a legal practitioner to really understand the standard you need to meet for the but-for analysis. And then also the facts of your case. You need to really make a factual case to the tribunal that there was, in fact, an FET violation that partially deprived you of your investment in that nation, and that your treaty allows you to recover that.
Right, so in thinking about the fair market valuation standard, as Richard was correctly saying, you could always, I mean, from a valuation standpoint, you can determine what the value would have been absent the damage or the cause that is being, contested, and what the actual value is after the fact actually happened. And if there is a difference and you can justify that difference, then that could be the exact measure of the damage. That is tricky in itself, right? So for example, if there was a loss of a very specific asset, let's say a machine was lost, then the next question is, should you be compensated for the value of that machine, or should you be compensated for the cash flow that you expected to generate from that specific machine, right? And then a whole lot of arguments could be made that that machine was never going to produce anything, or it wouldn't have produced anything in absent another factor, or then you start running into ex post information that becomes available. And the question becomes, can you use that ex post information, yes or no? Because it might be the case that ex post tells you, well, that machine would have been lost anyway. But at the point where the damage was occurring, you didn't know that, right? So it's tricky, as you correctly say.
And the factual analysis is extremely important, because you can have a company that develops the machinery and sells the machinery, right? And there's a company that uses the machinery and operates the machinery to provide services. And the difference in analysis in those two cases is completely different. Whether you consider the cash flow analysis or simply the sale value of the property.
Let me just give a couple of examples of this complexity of what's been mentioned here. For example, a breach happens, a company therefore has less money. Because it has less money, it has to borrow a little more. Because it borrowed a little more, it has to pay a little more interest. A coherent but-for analysis has to move through all of those steps and think through what happened as a result of the given breach in question. Another example might be that there's an investment agreement, and the parties to an investment, so, there's a consortium, there's a number of shareholders, for example, that they sign agrees, and they allocate the risks in different ways. And then a breach happens. And then that means that some things are going to happen to one of the shareholders, but not to another one, because of the way they structured their investments in the first place. Again, those types of things all have to be considered in what I would say a coherent damages analysis.
And I think your attorney needs to do a really good job at taking you from point A to point B and point B to point C, and for you to be able to establish by a preponderance of the evidence that you really have had damage based on the fact that you had to get an additional loan or get additional finance to finance your operation because the state did something against you at some point in time that affected that cash flow or affected your ability to operate under the economic conditions that you thought you had. So that is a very, very difficult factual analysis, in addition to the difficulties that you have stated and explained in calculating the damage itself.
Yes, and just to round this out, actually, I've seen tribunals go in different ways on this. I mean, I've seen some tribunals, for example, the example I gave of the investment agreement allocates risk between the shareholders in different ways. I've seen some investment tribunals accept that that was a part of that agreement between the shareholders was part of the factual matrix, which then affects the damages analysis. And I've seen other investment tribunals say, well, no, you can ignore that. That was something that the parties did just between themselves.
So let me go with this comment that you mentioned, the coherent but for analysis, and you mentioned also a practical example, and I don't want to go to critique any of previous cases, but Mexico, sorry, but I was not involved. Mexico, it was involved other persons that are here. Had these three cases, consecutive cases, ATM, Cargill, and CPI, that relates to the same measure. But in terms of damages, I don't know what is the reason that you think that each case will have a very separate standard of decision in terms of damages, or how treaties should try to prevent this type of results perhaps in the mind of the states?
Yeah, I can take that one. I was involved. No, not anymore. But no, I think one of the reasons why you could have different awards in the three cases, given that they stemmed from the same measure, is because the different investments of the three companies were at different stages at the point. So you could have one company which had been in the business for many, many years, had an established company, was generating profits, right? And that business would have to be valued in a different way than the business of another company, which just had recently invested in a very simple, let's say, transfer station of products, which was a minimal amount of investment, but they expected to generate a lot of revenue from that and profits from that. But the assets were clearly different, right? And so the measure in one scenario would not necessarily have to be exactly the same as another, because then one or the other would have been an unfair award, right? So obviously you have to see the context of the investment, and that goes back to the fundamental question. Should there be guidelines or very precise guidelines on how to value? I think those three cases show that would have been a mistake, because one of the three or two of the three or the three claims would have been misawarded.
And I agree with that last part, and taking on the second part of the question and not addressing the cases directly. I think it's very important to have flexibility in the framework of international treaties and documents. Especially in issues of damages that have such uncertainty and are so fact-based. So you need to be able, as a state, negotiating with another state, to create a treaty, let's say a BIT between Mexico and Peru, let's assume, and in the process of negotiating that treaty, you don't want to say, well, if your asset is worth $100, you're going to get $1. If your asset is worth $1 million, you're going to get $100. You don't want to make that scale, because you want to give your investors flexibility to argue before the tribunal that they are entitled to whatever they are entitled to based on the facts of the case and the language of the treaty. So you have to, as a negotiator, as a state negotiator, you have to give yourself the flexibility to protect your stakeholders, who in this case are your investors. And creating very hard line rules to determine the damages is normally a difficult situation, and it will put the investors of the state that is negotiating with the other state in a disadvantage, and would be probably not sufficiently protected in case their investment is taken in any of the many ways that they can be taken.
Okay. Well, I'll give just one word on this. I mean, I was not involved in any of these three cases, so let's say that.
Neither was I.
When I saw your notes and that you were going to ask this question, I scanned the awards. It strikes me from scanning the awards that any lack of specificity in the treaty language on damages is not where the differences come from in those three cases. I mean, and you may know more, but the one thing that struck out to me is in the two cases where there was a liability finding, the damages went into essentially looking at lost cash flows over a defined period of time. I think it was 2002 to 2007, more or less. But the difference between the assessments seemed to be the there were some underlying assumption differences about, what the FET breach meant economically. But one decision seemed to bring in profits that would be made outside of Mexico, and the other one said that wasn't appropriate. That to me isn't the damages standard question. That's just a difference in view of the two tribunals on the law about what's in and what's out. And then the third case, the investor lost on liability. So obviously there's no damages. So to me, the example, yes, there were different outcomes, but on my very quick reading of the award, I didn't see any of that was related to the damages.
If I may add one more thing, and this is a story, a personal one. When Peru negotiated its FTA with the United States back in the early 2000s, Peru found themselves, the Peruvian negotiators, and I was not one of them, but I was working with the Ministry of Foreign Trade, so I had some indirect participation. They were faced with the United States model BIT. It was basically here, sign. And when the negotiations took a little bit more, the form of an actual negotiation, the negotiators found themselves receiving the response of, no, we don't want to change that. Thank you very much. No, we don't want to improve that. Thank you very much. And that has been the practice not only of the United States, but many economies in the world that are exporting capital to less developed countries and who are drafting these treaties. So exporting capital countries have the ability to kind of direct how the drafting is going to happen and how the terms are going to end up with. So if they want to include a specific language determining what just and fair compensation or adequate and fair compensation or fair market value compensation actually means, they could do it, but they have not done it because they want to give their, as I said before, they want to give their stakeholders flexibility to argue in front of a tribunal the possibility of higher damages. So this is for capital exporting states and for countries who can influence the drafting of a treaty. This is all about flexibility. And I think that's the key for our analysis.
So based on this issue of flexibility, I will merge the two questions here. And in one hand, it's fine to have this flexibility, but in the other, should the tribunal have to have something as a guidance, for example, in the determination of which should be the methodology of valuation, whether it's a DCF, discounted cash flow, that barely remember how it works, but or market value, or a book method, or a type of guidance that deals with this, or the interest rate, no? Given the size of the claims that many countries are facing, should the tribunal or the parties should have any type of guidance? And when do you need to use a DCF or not? Or which type of rate should be used in the analysis of the damages?
So I think, again, flexibility is a key, and you correctly said that. But I think a minimum set of guidelines could be advantageous. And let me be more specific. If you look at the last few years, startups, especially tech startups, sprang up, and everybody was investing in these startups, and they, and you saw unicorns, companies that are worth over $1 billion spring up here and there, and everybody was in a frenzy to get their money into those companies, right? Companies which have not generated profits, of course, some not even revenues, yet they were valued very highly, okay? They had no track record, and so valuation was a bit, emotion driven, let me say that. And what we've seen in the last few months is that the majority of these companies are now about 10% of their peak value. So there's a huge variation in valuation simply because there is no track record, or there was no track record upon which to establish a fair value. Okay. Again, it was emotion driven. That said, I think if you wanted to apply the discounted cash flow measure, again, it's a prospective exercise, but it has to be based on something tangible. Let's say a long enough period of operating where you can actually predict, well, this company has been generating, $10 of profits on a consistent basis over the last few years. It's highly likely that it would have continued generating those $10 of profits going forward. Probably not 100, maybe not 1, around 10, right? So having a history of operation gives you a good safety margin upon which to base your DCF. But if you have a company with no track record at all, perhaps the better avenue is to determine, okay, how much were those assets worth? How much money did you actually invest? And then fair compensation could be based upon that, because nobody, honestly, could predict what amount of cash those assets could generate. So one guideline could be to give let's say, to specify a minimum period of operation in order to be able to apply the DCF standard. And if you don't have that track record, then you have to go to alternate methodologies. That could be let's say, a minimum viable guideline.
And this is where we're going to disagree.
Yes.
I would take issue with a number of the ways you characterize value there. In part that, of course, doing a valuation exercise and estimating FNV is inherently forward-looking. You have to think about what the asset will generate in future. That does not mean that the FNV itself is a subjective measure, because people trade assets on the basis of forward-looking expectations every day in the major stock markets of the world. Right? The FMV is a concept, value is a concept where I can see, and it may be that my future projections do not turn out to be what we all thought they were at a given point in time. They may end up being better or worse. That's why stock markets fluctuate. But the price on a given day can be an objective concept, even if we're looking forward to try and do that. So that's one thing I would respond to you. And then the next thing I would point to is that actually there are some valuation standards out there in the world at large. The one I'm going to point to is called the International Valuation Standards. It's the IVS. Gets updated every 5-10 years. The latest one, if I remember correctly, is the IVS 2022. It is, but what the IVS itself does not do is predetermine the value. So it has, for example, a definition of fair market value. In that standard, it's called market value. It sets out clearly what the underlying assumptions are. It discusses methodology that you might be using to come up with fair market value. But what the standard does not do is predetermine the valuation method itself, because that is too fact and asset and company specific to do so. There are some general concepts that you can define, like market value, like the hypothetical buyer framework and so on, but defining the methodology goes a step too far. I'll stop there. I can see other people.
So from my perspective, I'm going to change hats from advocate to the arbitrator. And I'm going to, as an arbitrator, I would realize that these two gentlemen in their different positions and their different perspectives on valuation will give me a speculation, a speculative value, a possibility of a value. And from there, I would assess whether that value is accurate based on the facts and the law. And that value would be determined based on the terms of the treaty, and that's the law, terms of the treaty, and any other applicable law that may come into play. That sometimes some local and domestic laws are applicable. And from there, move on to determine whether the facts assist or determine whether either one of the experts that I have in front of me are going to give me a reasonable value to determine what damages can I assess against the state that is also proving or providing a damages assessment that is lower. You know, one side is going to be lower than the other.
Let me actually just say one more thing on DCF per se. DCF, if you read a financial textbook, is not limited to assets which are already in existence and have a track record. In fact, DCF is the common tool used by people in the real world to evaluate major capital intensive investment. And you're looking, and that involves looking forward at investments without a reasonable track record. So, you know, DCF can be abused. Of course, any method can be abused. And it likely has been abused in both directions in various arbitrations historically. So certainly, but the method itself is applicable to development stage assets.
And absolutely. And so that's absolutely true. I mean, you can use DCF for assets that have never generated anything. And that's really the metric that is used out there in the real world. I think the key word here is speculation, right? How speculative is your projection going forward? If you, and you were mentioning that every day people make decisions on the stock market based on their views of the future, which is absolutely true. But you have the benefit when you do those speculations going forward that you have a track record of those companies that point you in a certain way, right? Will they perform a little better or a little worse than they have in the past? Has something occurred that might improve their performance going forward? So there are facts and there is a history upon which you can base your analysis out of, right? If you have a company or an asset that doesn't have any history to it, it's, you know, whatever you project going forward will become much more speculative, right? Because you simply don't know. It could be, the only thing you know is whatever you project is not going to happen. It's going to be better, it's going to be worse. But I mean, if whatever you projected happens, then you should, you know, work in a different line of work. You would make more money. So I think the question is how speculative it is the exercise, right?
Yes, I can understand.
We are running out of time, okay? So
I would say, okay, so two observations. One, you know, I'm not sure what you mean by speculation and what you mean by track record. There are stocks out there in the market where you see a price for an asset that hasn't been built yet. So people are trading and putting real money at risk, buying and selling shares at particular prices for things that don't, you know, properly are tangible in the real world. That doesn't mean to say the fair market value isn't there or the fair market value isn't an objective thing that you can see. You can read it in the newspaper, go to your Bloomberg terminal, find it. So that's, I guess, one thing I'd say. And then the other thing I'd say is that within the method itself, the real question comes down to how do you deal with risk? And where DCF gets abused is in two ways. It will get abused on the claimant side by somebody putting in rosy forecasts or too unreasonable forecasts, and then valuing an asset as if it were not risky when it really is risky. But that's a question of, that's not a question of the technique itself. It's a question of how you actually have implemented the DCF in practice.
okay. This is the last question, and it's a yes and no answer, okay? Because everybody's going. Okay. Is the lack of treaty provisions and damages is problematic in your view? Who wants to go first?
Let's do it in order.
Does it me first again?
Yes.
No.
No.
Okay. Thank you so much. Thank you. we will start at 3 p.m. and thank you so much for being here today and see you in the afternoon. Okay, this place, right? Okay. Nos vemos. Gracias.